Imagine a constitution that gives you a lot of rights. Sounds impressive, doesn't it? But here's a question. What if the government itself violates those rights? Who do you go to? And more importantly, who has the power to stop the government? The framers of our constitution had already thought about this problem, and that's why they included one of the most powerful provisions in the constitution, Article 32. And that's what we will talk about today. Hello everyone, my name is Rajni Jha. Welcome to Drishti IAS. So as I told you, today we are going to talk about Article 32, that is right to constitutional remedies. Now this right is a fundamental right, and like all other fundamental rights, it's present in the part 3rd of the Constitution. How would you remember it? See, our Constitution is divided into several parts, and you have to remember some of them and their provisions as it is, because they are asked in the examination. So we can start with country, because we are talking about a country. Country has citizens. Citizens have rights. And because we have given them rights, they also have to perform some duties. Right? And these duties are for state as well as citizens. By this, you can remember at least some of the provisions. So for country, what is included in country? Union and its territory. The union and its territory is included in country. This is part 1 of the Constitution. From citizens, you can remember citizenship. That is in part 2 of the Constitution. Rights, you can remember fundamental rights. That is present in part 3rd of the Constitution. And in the 4th part, there is duty. Now, duty for state is actually DPSP. Because DPSP tells the state what they should be doing, what goals they should be achieving for society. So, this is DPSP part 4. And the duties of the citizens, that is in part 4A. I hope you will be able to remember this now. So in the part 3rd, there is fundamental rights, and Article 32, that is right to constitutional remedies, it's itself a fundamental right. Now see, no matter how many rights you have been given, if there is no way to enforce them, they merely become promises. They are just promises, and promises can be broken. So this Article 32 becomes extremely important because it makes sure that other fundamental rights are enforced. They are not just promises, they are actually meaningful. So this Article 32 becomes extremely important, and that is why it has been called the heart and soul of the Constitution. Heart and soul of the Constitution by Dr. B.R. Ambedkar. So Article 32 itself is a fundamental right that gives you the right to directly approach Supreme Court for their enforcement, and apart from that, it is also a mechanism to protect all the other rights. Now there is another point that you should be noticing here, which is in case of violation of fundamental rights, we can directly approach the Supreme Court. Generally, what happens is, if you want to file a case, you have to go to district court, then high courts, then Supreme Court. But in the case of fundamental rights, if they are violated, you can directly approach the Supreme Court. Why is that so? Because the framers of our Constitution, they felt and realized that fundamental rights are so important that their violation and the resolution of it should not take a lot of years. If they are violated, the resolution for it should not take a lot of years. Let's say somebody is illegally detained or unlawfully detained. Now that person is not given any explanation as to why he has been detained, why he has been arrested. Now he or anybody on his behalf can go to Supreme Court and say that this person has been unlawfully detained. In that case, Supreme Court will give a resolution. Now if your fundamental rights are violated, you should not wait years for justice, and that is why this provision was included. So as we saw, it is the heart and soul of the Constitution as said by Dr. B.R. Ambedkar, because it guarantees protection. Okay, usually also the fundamental rights that you have been given as citizens, they are sort of protection against state's arbitrary action, that you have this right to speech, that you have this right to freedom, and because you have been given all those rights, the state cannot use its power arbitrarily, right? So they are protection for us, and this article 32 especially provides protection for those protections. That is why it is extremely important. Now in order for Supreme Court to give you a resolution whenever fundamental rights are violated, they can issue writs. What are writs? From writs you can remember these are written commands. These are written commands given by the courts so that they can ensure persons' rights and to make everybody follow the law. So these are given especially in two cases, in order to make somebody do something and in order to stop somebody from doing something. You'll see that in a while. So the first writ is habeas corpus. Habeas corpus is a Latin word which means to have the body of. What does it mean? The example that I gave you, where a person had been illegally or unlawfully detained, in that case, that person or somebody on his behalf can approach the Supreme Court and say that this particular person has been unlawfully detained. Now the Supreme Court issues this writ and says, bring that person here. To have his body of means bring his body here. Bring that person here, and if it is found that the arrest was unlawful, then that arrest is quashed. So the person is free now. Now because here the Supreme Court is asking to bring his body, habeas corpus is used. Now you can remember it like this. Habeas corpus is have the corpse of. See, corpse usually means dead body, but we are just trying to remember it with this because it sounds similar. Have the corpse of, meaning we will understand it like this: have the body of that person before that person becomes a dead body, because it's very much possible in arrests, right? So have the corpse of is habeas corpus, meaning bring that body here, bring the body of that person here. So this, where can this be issued and what does it ensure? It ensures individual liberty or personal liberty of a person, that you cannot arrest anyone arbitrarily. So it ensures personal liberty of a person. And the writ of habeas corpus can be issued against both public authorities and private individuals as well. Now these writs, who can they be issued against and where they cannot be issued? Both of them are also very important. Okay, where can't they be issued? Now, as I told you, it is issued when the arrest is unlawful. So if the arrest is lawful, in that case it will not be issued. So when detention is lawful, it will not be issued. Or when it is because of the contempt of legislature or court, in that case it will not be issued because that is lawful again. Or if it has been ordered by a competent court, then it will not be issued. And finally, it will not be issued if it is outside court's jurisdiction. See, here we are talking about Supreme Court, but writs can also be issued by High Court. I'll tell you that in a while. So let's say somebody has been unlawfully detained in Tamil Nadu and somebody on his behalf is filing a case in Delhi High Court. Then Delhi High Court will not be able to issue this habeas corpus because it is outside their jurisdiction. Supreme Court can issue anywhere in the territory of India. Next is Mandamus. How would you remember Mandamus? See, Mandamus, in Mandamus, what Supreme Court does, but what Supreme Court or High Court do is, they say, we command, you do your duty. That is Mandamus. They give a command to the authorities to do their official duty. So how can we remember this? Mandamus can be remembered as man, just do your duty, right? Mandamus is man, just do your duty. So here the courts are commanding authorities to do their official duty. For example, you know that you have fulfilled all the obligations required for passport, and yet passport office is not issuing your passport without giving any clarification, without any lawful reason. In that case, this can be issued and the court will say, why are you not doing your duty? Do your duty, and then your passport will be issued, right? So this writ can be issued to public bodies, corporations, lower courts, tribunals, government agencies to ensure that they perform their official duty. Where they can't be issued, where it cannot be issued, against a private individual. It cannot be issued against private individual or organization. It cannot be issued to reinforce or enforce departmental instructions without statutory backing. What does that mean? Sometimes the department gives an instruction, okay, if you do this, you may get this. In that case, it is not backed by law. May, should, these words ensure that this is not backed by law, this is just instruction. In that case, you cannot say, oh, the department said you might get it and it did not give me the reward or compensation, or it did not give me the whatever you were going for, right? It did not give you the documents. But it was only an instruction, it was not backed by law. So in that case, mandamus cannot be issued. Similarly, where the duty is discretionary rather than mandatory. Again, discretionary means, for example, they say, the same example, they say, if you fulfill this duty, we may give you a reward. Now that is not compulsory, that is not mandatory. It is on their discretion. They may or may not give you. In that case also, you cannot issue this. The court cannot issue mandamus. Then to enforce contractual obligation. If there is an organization who had a contract with the government, in contractual obligations also it cannot be issued. Next, against President of India or the state governor, because they get some immunity about their office work, right? Then against Chief Justice of India or High Court acting in judicial capacity, then also it cannot be issued. Next is prohibition. Now I'm sure you must have heard the word prohibit. Prohibit means to stop. So prohibition is stop. Where and whom are you stopping? So here what happens, let's say a lower court has taken up a case which is outside its jurisdiction. Now the higher courts will say, oh, stop, this is not your work, you cannot do that, this is outside your jurisdiction. So before the lower courts give any decision or verdict, prohibition is issued to make them stop giving any verdict. That is prohibition. So this writ is issued by a higher court or lower court or a tribunal, preventing it from acting beyond its legal authority or jurisdiction it does not have. It is issued only, now this is important, prohibition is issued only against judicial and quasi-judicial authorities. It cannot be issued against administrative authorities. For example, administration is when any public official, any government official is just doing the basic administrative work, like clerical work. They have just come to check your papers. That is administrative work, right? So it cannot be issued against administrative authorities, legislative body like parliament, or private individual and organizations. Now this writ, because it stops the courts from acting out of their jurisdiction, it is preventive in nature. This is called preventive writ because it stops an illegal proceeding before it is completed. Now what happens if the proceeding is completed? What if the court has already given a verdict but that case was outside their jurisdiction? In that case, what will happen? In that case, we have another writ, that is certiorari or certiorari. From certiorari, you can remember cancel. Now what happened is, let's say the court has already given the verdict, but that case was outside their jurisdiction. In that case, Supreme Court or Higher Court will give this writ and cancel or squash the order because it was outside their jurisdiction. Now with certiorari, there are two possibilities. First, when the case is already going on, then also the High Court or Supreme Court can say, this is out of your jurisdiction, you transfer this case to us. So it is preventive, just like prohibition. And if they have already given a verdict, in that case, it can cancel or quash that verdict. So it is corrective also. It is correcting their mistake. So it is preventive as well as corrective. Okay. Now this writ is issued by a high court or a low court or tribunal, either to transfer a case to itself, like I said, or to quash the decision made by lower authority, right? It is issued when there has been an excuse or lack of jurisdiction, again, if it is outside the jurisdiction of the court. Now, just like prohibition, it will also be issued against judicial and quasi-judicial authority, but there is one difference. In certiorari, now, it can also be used, again, it can also be issued against administrative authorities when they are affecting an individual's rights. What did I say? Certiorari can also be used for an administrative authority if that is affecting someone's rights, and this has happened after 1991 verdict by Supreme Court. So unlike prohibition, which only prevents future action, like I told you that before the verdict is given, prohibition is used. Certiorari can be used during that and after the verdict is given, both. So it is used to address past legal errors as well. Okay. Now, as I told you, in case of certiorari, it is also used for administrative bodies acting in a way that affects rights of an individual. For example, if a student is debarred, his rights are affected. If a license is cancelled, the rights are affected. In that case also, you can use certiorari. But if it is only for some other purpose, for example, office management also comes under administrative work. For that, it will not be issued. Okay. Next is quo warranto. Quo warranto means by what authority or warrant. From warranto, you can remember warrant. Warrant is authority, meaning you are in this office, but why are you in this office? What is your authority to be in this office? Do you have the qualifications to be here? That is quo warranto. It prevents illegal occupation of public offices. If somebody is there in a permanent substantive public office, anybody can question, do you have the eligibility to be here? If they don't have, then this writ is issued. So the court asked, what legal authority do you have to hold this public office? This writ can be issued only for a substantive public office, meaning a permanent nature, an important public office of permanent nature. It can be issued for that. Established by law or constitution. This has to be established by law or constitution. For example, the offices of bureaucrats or governor, prime minister, president, they are all by constitution. They are of permanent nature and they are important public offices. For this we use quo warranto. It does not apply to ministerial or private offices. First of all, in private institution or private organization, you cannot go and say, oh, why are you in this office? You cannot go and ask the CEO of a private institution, why are you here? You cannot do that, right? But it can be used for public offices of substantive nature and permanent nature. Now there is another point given here that you cannot use it for ministerial position. What is ministerial position? Now ministerial position does not mean ministers. The Council of Ministers that we talked about earlier, it is not that. In law, ministerial position also refers to the administrative work, the clerical work that I told you, that is also called ministerial position. So here when they are talking about ministerial position, they mean routine, clerical, administrative work which are carried out according to rule, right? That is administrative work and that is the ministerial work, not the Council of Ministers or the actual ministers in legislature that we talk about. Next is, unlike other writs, quo warranto can be filed by any interested person, not just the individual directly affected. Like in other writs we saw, if the individual is directly affected, they can approach the court in most of them. But here, because this is a public office and we want to question somebody, this can be done by anybody affected. Next, let's look at a basic difference of all these writs. First, we talked about habeas corpus, which means have the body of, here the body of the detained person will be produced before the court. Next is mandamus, man do your duty. So here the court command a public authority to perform their duty. Prohibition, to prohibit or to stop. So it stops a lower court from exceeding its jurisdiction. Next, certiorari means cancel. It does not actually mean cancel. I've just written this word so that you can remember. See cancel, see certiorari. So if an illegal order of a lower court is going on or it has already happened, then it will use to stop or cancel it. And next, quo warranto, to question the authority of a person holding the public office. Next, I told you that writs can also be issued by high courts, right? The Supreme Court issues writ, we know that, but high courts can also issue writs. So for high courts, that comes under Article 226. And there is one major difference between these two, and the difference is Supreme Court can enforce writs only for fundamental rights. High Court can also issue writ for other legal rights, not just fundamental but other legal rights. So this is broader as compared to this one. That is the basic difference. And yet Article 32 is considered most important because apart from the fact that it issues writs, it is also itself a fundamental right. That is why it is very important. Okay, the next part is, can Article 32 be suspended? We have already talked about this earlier in national emergency, that during emergency it can be suspended, and this happened after 44th Constitutional Amendment Act, that Article 20 and 21 cannot be suspended. Apart from that, every fundamental right can be suspended. And now we are at the last part of our session. We have two questions for you. First question is, consider the following statements about Article 32. A person can directly approach the Supreme Court for enforcement of fundamental rights. And second, Article 32 is available for enforcement of both fundamental rights and legal rights. You have to tell me which of these is correct. Option A is 1 only, B is 2 only, C is 1 and 2 both, and D is neither 1 nor 2. So I've tried to encompass everything that's important around this Article 32. I really hope that you enjoyed the lecture, you've understood everything. That's it for today's session. Thank you so much for joining in. Until next time, take care.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.